yes. We've been in similar places because I got my doctorate in North Carolina. So
Okay.
Yes, very long time ago. I was there.
Hey, say hey in person. Good, how are you?
There's been a lot of free speech.
Yeah, I think it'll be cool.
In my alma mater.
With the statue and all of that.
Yeah, and the board of
But I think
trustees.
every campus has it.
Yeah.
Yeah. And we just went through a name. I would say last week, 2 weeks ago, took a name off the law school because of his racist views. John bolted. We learned what he had said, and that was a huge kind of 2 year, 2.5 years going through that process. Which again is just every place is going through it. So.
Really? That's so nice.
And I mean, I was appreciating some of what you were saying in your book.
The live stream link.
People can turn it into kind of, not only a political but an intellectual project. They do the research they have for.
My parents once came to a presentation that I was doing at a conference, and I bombed it. You know, like I was so nervous because my parents were
especially happy with a couple of my students that asked questions.
But that's the times we live in. And often now it's
designated
want to
legal
come on
writing class, but
campus
it's
and
designated
That's
civil
what it
rights.
was.
Exactly.
What they most want is the university to keep
we
them
work on
speaking.
that,
so that they can,
So we had worked on that cross-border Bivens shooting case this past fall. And my students worked it out. Exactly. And what I'm hoping
off my
to do
game.
is, I'm sure that we're going to lose at the Supreme Court. What I'd really like to do is pick up that case and take it to the Inter-American Commission on Human Rights.
He does have a lot
on
of
a right to access to justice claim, arguing that Bivens itself violates a fundamental right to
ramped
not a
up
good
so
idea.
much, or maybe we're just small potatoes, so it wasn't. There was no point in exemplifying.
I need the coffee more than
and they were getting it. It was amazing. Yeah.
Because that was a classic moment. They could have said, "Oh, the left wing has taken over UIC," and
Yeah, and Berkeley is so easy as a symbol.
it's such an easy target. Yeah.
And so he looks for that, even if there's nothing. There was an incident last year where someone off campus was punched by somebody off
read the book. I wrote
campus.
a
Didn't
couple
involve any
questions down, but I'm
faculty
just
members,
going to
staff
listen to what he
members,
says.
students. It just happened
Try to
on
respond.
campus. And Trump used that as his poster about how campuses don't tolerate free speech.
You know, I saw you were
There was
department chair,
nothing in the
right?
world the
So
campus could have
chair
done.
for it's my 6th year.
But it's
So,
Berkeley,
I mean,
and it's an easy target.
I can already see some of this stuff bubbling up, at least in the small scale in my department, right? So thinking about it from the administrative perspective is really
in Oakland,
I already have
in
some
Oakland and San Francisco, and in that moment, right, the free speech movement moment. So we're living. That has that. It's still there. That legacy.
Right, social media stuff.
I had not seen, I'd been to the Berkeley campus many times, but I'd never seen Saturday.
Oh, wow.
And then it was amazing to go there. This is Sprout Plaza. It's how small it is.
Yeah, I know.
Then I had in my imagination had this great, grand area. And
because it has this sort of majestic.
Right.
And
it's just
and you're there on an average day, and it's just school kids with their backpacks going under the gate.
Exactly.
Mostly, as you said, oblivious.
Earned is very loose word.
But I was in California during Prop 209.
No, I think it'll be really interesting. I think
all of that boiled up.
Irwin has
I was at USC from '83 to 2004. So it's all cases,
right?
And I think it's going to be interesting to have a conversation about sort of other.
You enjoying living in Chicago?
The issue.
Love it. Absolutely love it. It's an extraordinary place, particularly for my work. It's so rich, and it's just a great place in terms of arts and culture.
Right.
You have to come back when it's not
I
freezing out.
My mom, brother, and sister are all still in the Chicago area.
One of these campus
so
conversations.
come always to see
never seen
them.
one.
But I come between April and October.
Me too. We're on the same
I'll see you then. Because of this having to be a short trip, because my teaching said, I didn't even tell my mom I'm in town. And it'll be very strange. I'll talk to her on Sunday and not even mention, I was in Chicago on Thursday. It was really cold and snowy.
I've heard of people shooting.
It's just,
It's a lot.
well, I taught yesterday from 2 to 3:30, and I canceled today's class.
Yep.
Yeah.
All right, we ready? What we understand is lots of people stream. We will stream this. I think people stay there.
I don't blame them.
What's the order?
So I'm going to introduce you.
Steve Schwinn.
Ben's super fun.
Then you guys, I'm Joe.
So nice to meet you.
Hey, how are you?
Okay. And then start the conversation. We'll do that for about 30
Ben.
minutes.
Ben's
Yep.
super fun.
We'll be collecting
Okay.
questions.
Okay, so you want us to sit here? Perfect.
Okay.
Perfect.
I was sorry to miss you guys at lunch, but I have a colleague from the University of Milan.
That's what you said, and I got to meet her briefly this morning.
And we got something lost in translation. I didn't know she was going to come this morning, but I was so thrilled.
It's like
that
being the
she
kids
did,
who sit in the
and she
front
just
row.
had wonderful things to say about your
Oh,
presentation.
that's okay.
I understand why they avoided.
Good afternoon, and welcome to the campus conversation, our fourth of this academic year, and our first or second of the semester. I think it's our first of the semester. The goal of the campus conversation series is to have faculty, students, and staff engage with each other about some of the big issues of our time going on now and affecting all of us. As a community dedicated to social justice and diversity, we come together to try to understand current events and to talk about the issues. Over the past 3 years, we've looked at issues such as immigration, civil rights, national and local elections, the hashtag #MeToo movement, our general education program, and mental health, among others. And we have 2 more programs yet this semester, the last of which will be a discussion of Mayor Lightfoot's first year in office. The next one, we are still debating whether to go ahead with climate change or change it to something about all this stuff going on in DC. So we may do impeachment, we may do prosecutions, all kinds of things. So stay tuned for that. Today, the topic is free speech on campus, and we are honored to have with us Wynn Chemerinsky, the Dean of the Law School at the University of California, Berkeley. And I will introduce Dean Chemerinsky in just a moment. Dean Chemerinsky will speak for about 30 minutes, after which our own panel of faculty will engage with him in a discussion on the topic of free speech. I'll remind you that this is being streamed, and it will also appear on my website after a couple of days. Our faculty panel consists of Dr. Zizi Papakrisi, who is the department head and professor of communications in LAS and professor of political science, Dr. Jane Rhodes, department head and professor of African American studies in LAS, Steve Schwinn, who's a professor of law at the UIC John Marshall Law School, and Benjamin Supervine, professor and chair of the Department of Educational Policy Studies in the College of Education here at UIC. And they will come up following Dean Chemerinsky's talk. So we will follow then the panel discussion with a Q&A session with the audience. Paper has been provided on your chairs, I think, with a little pencil. And so as you think of questions, write them down, and Kelsey will come around and collect them during the panel discussion, and we will adjourn at 2 p.m. So it's now my pleasure to introduce Wynn Chemerinsky. And this introduction is very, very abbreviated, as you will see once he gets up here. You'll be able to imagine the long resume that he has. Wynn Chemerinsky became the 13th Dean of Berkeley Law on July 1st, 2017. Prior to assuming that position, he was the founding dean of the University of California Irvine School of Law. And before that, he had distinguished professorships at Duke University and the University of Southern California Law School. Dean Chemerinsky is the author of 11 books, that's probably already wrong at this point, including leading case books and treatises about constitutional law, criminal procedure, and federal jurisdiction, as well as books for popular audiences, including his recent book entitled Free Speech on Campus, which he wrote with Howard Gilman. He's the author of more than 200 law review articles. He writes a regular column for the Sacramento Bee, monthly columns for the ABA Journal and the Daily Journal, and frequent op-eds in newspapers across the country, including one in the New York Times just yesterday, although it was not about free speech, it was about baseball. He frequently argues appellate cases, including in the United States Supreme Court, where last fall he was one of the lead attorneys defending the DACA program before the court. In 2016, Dean Chemerinsky was named a Fellow of the American Academy of Arts and Sciences. In 2017, I think not for the first time, the National Jurist magazine named him the most influential person in legal education in the United States. It's been my pleasure to know Wynn Chemerinsky over the years in the legal education circles, and it's my great pride that he is now my dean of my alma mater, law school. So please join me in welcoming Wynn Chemerinsky.
Thank you. Thank you so much. Thank you so much for the very kind introduction. It's truly an honor and great pleasure to be here. What Susan didn't mention is that I grew up in Chicago, and I have to admit that today reminds me why I live in California. For most of us, our image of free speech on campus might involve the free speech movement of Berkeley in the mid-1960s. It involved students on campus demonstrating, trying to claim a right to speak about issues that were unrelated to university administration. However, now things are quite different when we talk about free speech on campus. Frequently today, it's about outsiders wanting to use the campus as a platform for expressing their ideas. There was an incident at Berkeley a few years ago where Milo Yiannopoulos came to speak, and the group Antifa demonstrated, engaged in violence in a way to prevent him from being able to talk. We had an incident on the Berkeley campus just in November, a few months ago, whereas Ann Coulter wanting to use the campus to express her views, and outside groups wanted to agitate to try to prevent that. Also, student attitudes have changed. My guess is that if somebody had taken a poll of the students at Berkeley in the mid-1960s, there would have been overwhelming support for the free speech movement. But now, there's a much greater diversity of views among students when it comes to free speech. There was a study by the Pew Research Institute that found that 43% of the undergraduates surveyed believed that campuses should prevent offensive and hateful speakers being able to appear on campus. I've certainly seen that on my own campus. In 2017, a campus group calls themselves the Patriots and invited Milo Yiannopoulos, Ben Shapiro, Ann Coulter, and Charles Murray to all be there in 1 week. The chancellor convened a faculty panel to discuss the issue that we're focusing on today, free speech on campus. It was in a large auditorium. Every seat was taken, every floor space was occupied. The first faculty member to talk was my colleague, John Powell, and he said that he believes that the largest problem in our society is white supremacy, and that the chancellor simply should exclude any hateful speakers. There was resounding applause from the audience. After the panelists, the faculty members spoke, the students were able to speak and ask questions. And one student stood up and very eloquently said that she feels threatened when there are hateful speakers on campus, like Milo Yiannopoulos and Ann Coulter. And she wants the chancellor to stand up on behalf of the students. She said she wants the chancellor to exclude such speakers no matter what the courts or the First Amendment say. And again, there was resounding applause from the audience. I was one of the faculty members on the panel, and I then spoke and said, let's be clear about this. If the chancellor were to exclude any of these speakers, she would get sued and she would lose. When Auburn University tried to exclude the white supremacist Richard Spencer, he and his supporters sued and won. At the very least, the campus would have to pay the attorney's fees for the excluded speakers. But because the law is so clear here, the chancellor might even be liable for money damages. The excluded speakers would make themselves out to be martyrs and victims. They would get to speak anyway, so nothing would be achieved. No one applauded when I said that. And so it's this context that today we can talk about free speech on campus. I was trying to think what I might be most useful in doing in setting up the panel discussion. And I thought what I would do is try to summarize my understanding of the law in 4 points. First, all ideas and views can be expressed on a college campus. Period. The very core of the First Amendment is that the government never can prohibit or punish speech based on the idea or the viewpoint of the message. Now, I'm obviously here speaking of public college universities like USC or University of California, Berkeley. The First Amendment applies only to government institutions. If we were talking about private institutions, it's a much more complicated story, but it's not a story then about the First Amendment. I can certainly point to many Supreme Court cases that stand for this proposition that all ideas and views can be expressed, no matter how offensive. The Supreme Court case earlier last decade, a case called Snyder versus Phelps. And though you might not be familiar with it by name, the facts probably are ones you've heard of. It involves a small church out of Topeka, Kansas, the Westboro Baptist Church. Its members make it a practice of going to funerals of those who died in military service and using it as the occasion for expressing a very vile anti-gay, anti-lesbian message. The members of the Westboro Baptist Church traveled to Maryland. It was a funeral of Matthew Snyder. He was a Marine who died in military service in Iraq. Before the funeral, they asked the police where they could lawfully stand, and the officers pointed an area about 1,000 feet away from the ceremony held. Before the ceremony, they chanted and sang. During the ceremony, they were silent, but they held up signs. That night, Matthew's father, Albert Snyder, was watching the news, and he was able to read the signs. He was deeply offended. He sued the members of the Westboro Baptist Church for invasion of privacy and for the intentional infliction of emotional distress. A jury in federal court awarded him $10 million in damages. But the United States Supreme Court, 8-1, ruled in favor of the members of the Westboro Baptist Church and against Albert Snyder. Chief Justice Roberts wrote the opinion for the court. He made clear that above all, the First Amendment protects the right to express ideas and views, even very offensive, even very hateful ideas and views. And this is true campuses for public universities as much as anywhere else in the country. But this leads me to my second point, and that's free speech is not absolute. We've all heard the famous words of the late Justice Oliver Wendell Holmes that there's no right to falsely shout fire in a crowded theater. At least since the early 1940s, the Supreme Court has said that there are categories of speech that are unprotected by the First Amendment. So in these instances, the government could punish, prohibit speech. There are a few of these categories that are relevant to our discussion today of free speech on campus. One is incitement of illegal activity is speech that's not protected by the First Amendment. The Supreme Court has said this for a century now. But it's important in talking about these concepts to separate the legal test that's used under the First Amendment from the colloquial use of the word. The court has adopted a legal test with regard to incitement that makes it very difficult to prove that the speech is unprotected by the First Amendment. In a case called Brandenburg versus Ohio in 1969, the Supreme Court said, in order to be incitement, there's to be a substantial likelihood of imminent illegal activity, and the speech has to be directed at causing imminent illegal activity. Well, to make this more concrete rather than abstract, I want to compare a couple of examples. Imagine that there's an angry group on campus, and a speaker talks to them and exhorts them to commit acts of vandalism, arson, lighting building on fire. Could that speaker be punished for incitement? I think so. The facts of my hypothetical. On the other hand, imagine a situation where Milo Yiannopoulos comes to campus and there's a strong reaction against him. Can Yiannopoulos be punished for incitement? Not in those facts, because it was the reaction of the audience against him, not him encouraging them to go out to commit acts of violence. And under the First Amendment, the reaction of an audience doesn't justify suppressing the speaker. A second category of unprotected speech that's relevant to our discussion is called true threats. It's a phrase that comes from the United States Supreme Court. The case that originated this was United States versus Watts half a century ago. It follows a federal law that's still on the books that makes it a crime to threaten the President of the United States. The Supreme Court said, if it's a true threat, then it's speech that can be punished. On the other hand, if it's mere hyperbole, it's protected by the First Amendment. The Supreme Court Other cases said that true threats are unprotected by the First Amendment, but the court has never given us a clear definition of what's a true threat. In fact, there's even a split among the Federal Court of Appeals about how to define it. My view is there's no First Amendment right to cause a person to reasonably fear for his or her physical safety. If the speech is directed at somebody and causes that person to fear for his or her safety, it's not safeguarded by the First Amendment. Again, I'll contrast a couple of examples. Imagine a student is walking across campus, and an angry group surrounds that student and yells at the student in a way that he or she feels about to be beaten. Even if no blows are actually struck, those who made that student fear for his or her physical safety could be punished for a true threat. On the other hand, imagine that a speaker comes to campus like Milo Yiannopoulos or Ann Coulter. When Ann Coulter came to the Berkeley campus in November 2019, I heard some of my students say that they felt threatened by her very presence on campus. That's not enough to be a true threat. The ideas expressed can never be the basis for saying that somebody is threatened. A third category of unprotected speech that's relevant to our discussion is harassment. The Supreme Court has been clear, especially in the employment context, that speech that amounts to harassment can be the basis for liability. Think of the easiest example. Imagine an employer who says to an employee, "Sleep with me or you're fired." It would be no defense for that employer to say, "I was just engaging in speech." In the employment context, the courts have said that to be harassment, the speech generally has to be directed at somebody, or has to be so pervasive as to materially interfere with employment opportunities based on race, sex, religion, or sexual orientation. I think the same standard should apply in educational institutions, that to be harassment, it generally has to be directed at somebody, or so pervasive as to materially interfere with educational opportunities based on race, sex, religion, sexual orientation. Again, let me contrast a couple of examples. Imagine that somebody tacks what appears to be a noose on a dormitory door of a room occupied by an African-American student. I think that is clearly harassment. I think it rises to the level of a true threat. On the other hand, there was an incident at the University of California, San Diego, where somebody put in the library what appeared to be a noose. I don't believe that single action, though vile, could be a basis for punishment. It wouldn't by itself be enough for harassment. Now, for each of the categories I mentioned, there's certainly a gray area. When does the speech become incitement? When does it rise to the level of a true threat? When is it enough to be harassment? And these are things that would need to be argued about or even litigated. But you'll notice what I didn't identify as a category of unprotected speech, and that's hate speech. And that's because generally hate speech is protected by the First Amendment. I have so often been asked by members of an audience or by reporters, where is the line drawn between free speech and hate speech? And I have to say that's a false distinction, because in the First Amendment, the Supreme Court has been clear. Hate speech is protected as free speech. You might remember an incident that occurred here in the Chicago area in the late 1970s, where the Nazis wanted to march in Skokie, Illinois. At the time, Skokie was a predominantly Jewish suburb, had a significant number of Holocaust survivors. That's why the Nazi Party chose to march there. Skokie did everything it could to try to exclude the Nazi demonstrators. Every court, including the Supreme Court, ruled that the Nazis had the First Amendment right to speak in Skokie. In 1992, the Supreme Court decided a case, RAV versus City of St. Paul. It involved a St. Paul, Minnesota ordinance that prohibited burning a cross or painting a swastika, vile symbols of hate, in a manner likely to anger, alarm, or cause resentment. The United States Supreme Court unanimously declared that unconstitutional, making clear that such hateful speech is protected by the First Amendment. In 2003, the Supreme Court decided Virginia versus Black. It involved a Virginia law that prohibited cross burning. The Supreme Court 8-1 said that cross burning is protected by the First Amendment, notwithstanding its racist history, unless it amounts to the level of a true threat. Why is this? After all, almost every European country has a law that prohibits hate speech. Why in the United States is it so different? In part, I think the answer is the difficulty of trying to define hate speech in a manner that's not unconstitutionally vague or overbroad. Any law that regulates speech has to be specific about what's prohibited and what's outlawed. And yet it's very difficult to formulate a definition of hate speech that doesn't run afoul of the prohibitions with regard to vagueness and overbreadth. In the early 1990s, over 360 colleges and universities adopted hate speech codes. They were all well-intentioned, but every one to be considered in a court, without exception, was declared unconstitutional, almost always on vagueness and overbreadth grounds. One of the first cases to come to court involved the University of Michigan hate speech code. Following a series of ugly racist incidents, the University of Michigan adopted a hate speech code. It prohibited speech that stigmatized or demeaned on the basis of race, sex, religion, and sexual orientation. And that uses language that's common in European hate speech statutes. But what does stigmatize or demean mean? One of the plaintiffs was a sociobiology graduate student, and he said his research was about whether or not there are inherent genetic differences between men and women. He said he worried that his speech might be thought to stigmatize on the basis of sex. In Doe versus University of Michigan, the federal court found that this hate speech code was unconstitutionally vague. So the experience under these hate speech codes and under hate speech laws in Europe should give us some pause about embracing them. So often they are used against the very groups that they're meant to protect. When England adopted its first hate speech law, the initial prosecution under it was against a Zionist group. The prosecutor said that he believed that Zionism was a form of racism, so advocacy of it was hate speech. At the University of Michigan, from the time its code was adopted to when it was struck down, every disciplinary action under it was against an African American or a Latino student. But maybe most of all, hate speech is protected in the United States because it expresses an idea. It's a vile idea, it's an offensive idea, but it's still an idea. And under the First Amendment, all ideas and views are protected. My third point is that colleges and universities can have time, place, and manner restrictions with regard to speech, so long as they've opened adequate alternative places for communication. Even when there's a right to use government property for speech, it doesn't mean that any piece of government property can be used at any time for any manner. There's certainly a right here in Chicago to use public sidewalks and streets for speech, but that doesn't mean that somebody can have their protest during the middle of the Dan Ryan Expressway at rush hour. Colleges and universities can use time, place, manner restrictions to prevent disruption of campus activities and also to protect safety. With regard to protecting against disruption of campus activities, college universities could say, for example, no demonstration or protests outside of classroom buildings while classes are in session. There can be free speech zones so long as they leave adequate places for communication. I've always believed there can be greater restrictions of speech in and near dormitories because it's a place of repose for the students who live there. At the same time, I believe that colleges and universities have a legal and an ethical obligation to protect the safety of their students, their staff, and their faculty. And they can use time, place, and manner restrictions to achieve this. When I came to Berkeley in the summer of 2017, the Chancellor, Carol Christ, was very kind and asked my advice about the coming Free Speech Week activities. And And I said that my advice would be to have the most controversial speakers in an auditorium rather than the open area of campus. Because if it occurs in an auditorium, it's possible to, if necessary, use metal detectors. IDs can be checked. If it's necessary, the perimeter can be secured. But as an open area, like Sproul Plaza on the Berkeley campus, it's impossible to do that. So when Ben Shapiro came to speak, they said it had to be in an auditorium. They let him have the largest auditorium on campus, Zellerbach Hall. And he objected. He said he wanted to be able to speak in the middle of campus. And he spoke, there was no incident, but he and his supporters sued and said that he should have had the right to speak in the middle of campus and not have to speak in an auditorium. The university won that litigation. The court saying, as I predicted it would, this is a time, place, manner restriction. I think one of the hardest issues that's going to come up with regard to this is how much must a college or university pay in order to assure safety? At what point could a college or university say, we just can't protect safety, and that therefore we're not going to allow this speaker who's likely to inspire an angry response? I mentioned the Free Speech Week in September 2017 at Berkeley. The security cost the campus $4 million for just that short period of time. Every dollar of that, of course, is coming from other aspects of the educational mission of the university. But what if it wasn't Free Speech Week at Berkeley? What if it was Free Speech Semester? What if the cost wasn't $4 million, but $40 or $60 million? Surely there is a place at which the campus has to be able to say, we can't afford the security, and therefore we're not going to allow this controversial speaker. But no court has yet addressed that question. Chancellor Christ asked me that question directly. How much does the campus have to pay before it can say it's not going to allow the speaker? And I said, I'm not your lawyer. You have campus counsel. But if I were your lawyer, what I would say is you have to ask two questions. One is, what's your stomach for litigation? Because there's no cases on point, you're going to get sued if you exclude the speaker. And you might win and you might lose, and if you lose, you'll have to pay the other side's attorney's fees. Do you want to take that risk? And I said, second, what do you want your message to be about the Berkeley campus? She decided, I think rightly then, that she wanted the message to be that Berkeley was a free speech campus, chose to absorb the security costs and allow the speech. But the issue remains unresolved, and campuses across the country have to face it. Fourth and final point. Colleges and universities have the duty to protect their students from harassment. Now, I have focused on the free speech side of the equation, but college universities have both the legal and the moral duty to create an inclusive learning environment for all of their students. This, of course, must recognize the way in which speech can undermine that. If free speech had no effect, we wouldn't protect it as a fundamental right. The effect of expression can be positive. It can be tremendously destructive. I am certainly moved by those who talk about the harms of hate speech on those who are traditionally excluded from colleges and universities. In fact, I was involved as a lawyer not too long ago in representing a group of students against their university. The case is Feminist Majority Foundation versus Mary Washington University. Mary Washington is a public school in Virginia. There was a campus-wide debate on whether to allow Greek life, fraternities and sororities. 3 women wrote an op-ed in the campus newspaper opposing allowing fraternities at the school. Their argument was that there's a correlation between having fraternities and more violence against women. These women were then targeted by other students on campus. There was then a social media platform called Yik Yak. Over 700 messages were directed at them over Yik Yak, many of them very vile, some of them threatening rape and murder. The students went to the campus administration, and the campus said, we can't do anything about this. This is anonymous speech over social media. The campus administrators put something on their website saying, if it's anonymous speech over social media, we can't do anything about it. The students sued the university under Title IX, which says that recipients of federal funds cannot discriminate on the basis of sex. Sexual harassment violates Title IX. The law is clear that college universities cannot be, quote, deliberately indifferent. They also sued for denial of equal protection. The federal district court ruled in favor of the university, saying that this is free speech over social media protected by the First Amendment. I represented the students and argued the case in the United States Court of Appeals for the Fourth Circuit. My argument was that there was much that the campus could have and should have done without ever getting to the point of considering punishing speech. The campus administrators could have spoke out against the hateful expression and spoke out in favor of these women students. The campus could have offered to provide protection for these students when they were threatened with rape and murder. The campus could have considered a cyberbullying policy. But when the speech crossed the line to true threats, and some of it really did, then it's speech that could and should have been punished by the university. On December 21st, 2018, the Fourth Circuit ruled in my client's favor. And the Fourth Circuit adopted the arguments that I've just expressed to you, that the college did have the obligation to protect the students from harassment under Title IX and under equal protection. And I think this case is important for college university administrators to know that they can't do nothing. They have to consider what is the appropriate response under the circumstances. Often, the appropriate response is more speech. Sometimes it's by college and university administrators. Often it's by the students. When the white supremacist Richard Spencer came to Texas A&M, there was a large counter-demonstration in the football stadium. And I've talked to some faculty and students who were there and talked about how unifying and affirming it was for people to come together in that way. I believe that social media and the internet are going to be the hardest free speech issues for campuses in the future. It used to be possible to draw a distinction between speech on campus and speech off campus. As the Mary Washington University example shows, such a distinction no longer makes any sense. Well, I've tried quickly to go through a number of principles, basically in 30 minutes to cover what I do in a semester of First Amendment law. But I realize that I may not have persuaded everyone, and there are certainly many who think there should be much more restrictions on hate speech than I've argued for. I think what I have to say to you is my realization that the only way my speech, our speech, will be safe tomorrow is to protect the speech that we don't like today. That the assumption of the First Amendment is that we are much better off allowing all ideas and views to be expressed than to giving those in power the ability to decide what ideas and views can be expressed. There's a faith in that statement, and I have that faith, at least most of the time. Thank you. I know, it feels so ostentatious to sit in this chair. I feel so self-conscious sitting here.
Anyway, the panel would like to reintroduce themselves since I introduced you while ago.
Hi, everyone. Good afternoon. I'm Zazie Papakarisi, Department Head for Communication, also with an affiliate appointment in political science, and I study technology and its social and political impact.
Hi, I'm Jane Rhodes. I'm the head of the African American Studies Department in the College of Arts and Sciences.
I'm still Wynn Chemerinsky.
I'm Ben Superfine. I'm professor and chair of the Educational Policy Studies Department.
I'm Steve Schwinn. I teach at the law school. I teach constitutional law and human rights.
Can we start? Oh. Well, when the provost invited us to join you in this conversation, she suggested that we think of some questions to engage you in lively conversation, but your perspective is so balanced and learned and thoughtful and informed. The questions that I had jotted down have all been answered, and I was panicking trying to come up.
Would you talk to my students? They don't always have their perception of what I say is mean.
But I was really intrigued and very happy when you brought in the European context, and in particular, I think the EU context, because often people confuse those two. And I was wondering if I could get you to talk about that a little bit more. So my interest is in hate speech. So when we think about whether people who talk about restricting the freedoms of others, do they have the same right to free speech? And we think of countries in the European Union who have made use, availed themselves of a regulatory framework that permits them to distinguish between hate speech and free speech. To what extent do you find that here in the United States we might be interpreting the Constitution and the room that affords in a way that's not very contemporary, especially when we expand the idea of free speech and we think of more contemporary developments that you mentioned that include social media that seem to concern you as in terms of being friendly to toxic forms of speech.
I think there is a deeper commitment to free speech here than in many other countries, for better or for worse. One of the things that I did was look to see how the hate speech laws had been used in other countries, and I was stunned how often they had been used against speech that all of us would say should be protected. The most frequently prosecuted person under the French hate speech law is the animal activist Brigitte Bardot, because she's very much against using animals in religious rituals and has many times been prosecuted and convicted for violating France's hate speech law. Well, I can go through examples country by country of that. I also think, looking at other countries, that I'm skeptical that prohibiting hate speech is really going to decrease hate or hate crimes. That I think that the effect of it is often to drive it underground, often in that way to make it more attractive, to make those who are prosecuted under it into martyrs. And you see so much of that around the world too. So yes, I think the United States is different in this regard. The culture with regard to speech is different. But I'm not sure that the experience of the other countries would change my sense that we should go more in that direction.
I, too, like Zizi, I have enjoyed and learned an enormous amount, both from your book and from your talk. So thank you so much. I want to be a little bit provocative and sort of push this envelope about hate speech further, because you present us with, I wouldn't say an idealized notion of how it can operate, especially on a university campus, but certainly the way that it should, right? The exchange of ideas, the tolerance of hateful speech. But I think the students and the administrators and the faculties and people like myself who sort of push the concept of safe spaces are often operating from the reality that there are subsets in our communities who bear the burden of speech, particularly of hate speech. You know, when I think about my own experience, when I think about my students, whether they're refugees or immigrants or trans or whatever their identities are, there are subsets within the nation, within our communities, that experience vastly larger amounts of hate speech. And so it seems to me, and I wonder how the law deals with this, that there's a cumulative effect. And that does that give sort of a greater claim? Thinking about the Holocaust survivors in Skokie, and I know the case law, the Supreme Court said no, they didn't have a sort of greater claim on protection. But how, particularly in this very sort of toxic environment of social media, and as you described, the sort of political uses of free speech precisely to sort of bludgeon or attack or injure opponents, how do we sort of make sense of that and navigate that?
I in no way deny the harms of hate speech that you describe. I very much believe what you say and what commentators said is absolutely right. The question is what conclusion we draw from it.
Right.
I also believe in safe spaces, but I think we've got to be very careful in how we use that phrase. If what we mean by safe spaces is the obligation of the campus to protect the physical safety of students, absolutely, it's a legal and it's a moral obligation. If what we mean by safe space is a place of repose where people can go to, I support that. So I believe that there should be African American student unions, Hispanic student unions, and the like as a place where people can go. But if what's meant by safe spaces is that people should be made safe from certain ideas and viewpoints on campus, there I strongly disagree. I can tell a couple of incidents on my campus just this year. I mentioned that Ann Coulter came and spoke at UC Berkeley in November of 2019. It was not at the law school or sponsored by the law school. The morning after she spoke, some of our students sent me videos that as students and others were going in to hear Ann Coulter, they were assaulted. They were physically punched, shoved, spit at, water was thrown on them. And after watching the videos and talking to some of our students who experienced this, I wrote an email to all of the students, staff, and faculty saying, as I did to you today, that I believe that all ideas and views can be expressed on a college campus, that if we don't like certain ideas and views, the response should be more speech. It shouldn't be to engage in harassment or assault. And I said that I had seen the videos of what occurred with regard to Ann Coulter and described what I'd observed and that this is inappropriate behavior. I tried to be emphatic. I think it's completely appropriate to protest against what Ann Coulter is saying. But as a law school, we have to stand up for free speech and that this is not acceptable behavior. Many of my students did not warmly receive that message. Posters were put on every bulletin board through the law school with my picture saying that I stood up for Ann Coulter's free speech. Why didn't I stand up for the students who feel threatened by Ann Coulter's presence on campus? A student came to my office and said, your message was like, quote, a slap in the face to me. A group of students sent me an email saying that they felt that Ann Coulter's presence on campus was violence against them. I don't believe that the presence of a speaker on campus is violence against them. I don't believe I was standing up for anything other than Ann Coulter has the right to speak on campus, which I think she has. But it's clear my students believe that part of what a safe space should be about is we should exclude a speaker like Ann Coulter. What scares me is if today it's Ann Coulter, tomorrow it's me. I do know enough about what went on in the early 1950s to know speakers were excluded just because of the need to make students safe from certain ideas. And it troubles me. A week ago Monday, there was an incident on the Berkeley campus where Students for Justice in Palestine put up 3 big posters that had pictures of individuals who had been convicted of terrorist activity in Israel. Jewish and Israeli students on campus felt that they were threatened by these posters being put up. I think the chancellor was absolutely right in the message said they have the right to put up their posters, and you have the right to criticize and denounce the posters, but both sides have to speak. Would I deny that it causes an emotional injury for a DOC recipient to have Ann Coulter on campus? No, I believe there's an emotional injury. Do I believe that a student from Israel whose family was lost in a terrorist bombing is upset by seeing those posters? Absolutely. But I don't think safe space can mean we protect our students from ideas or views that will upset them.
Okay, thank you. Can I follow up on a related question? Thank you so much. A number of the examples that you provide both in your book and in your talk illustrate the ways in which free speech is sometimes a guise for other sort of political motivations and strategies. And you know, we know that people can utter speech that saying that it's freedom of religion, for example, but it's really sort of targeted at sort of causing harm. And I understand that what you're trying to sort of map out for us is how difficult it is to sort of understand that and measure that in a legal sense. Is there any standard for harm in terms of free speech? I know there is in libel law, for example, Is there an argument that can be used in terms of harm?
It depends on the harm that you're talking about. Incitement laws about preventing the harm of illegal activity resulting in speech. True threats is about protecting people from the harm that comes through assaults. Harassment law is about protecting a certain kind of harm. Defamation law is protecting harm reputation. So there's certainly instances where we said the harm is great enough and the ability to define the unprotected speech is specific enough that will outlaw the speech. I don't think we've ever found a way to do that with regard to hate speech. I, for a few years when I was at University of California, Irvine, taught an undergraduate class on free speech on campus. I co-taught it with the chancellor, Howard Gilman, who I wrote the book with. And we would ask our students as an exercise to draft a hate speech code that wasn't vague or overbroad. And it was interesting that even many of the students who would be supportive of such a code found that to be an elusive, not an impossible task.
I guess we'll go down the line. So I also enjoyed the talk. I'd like to flip it around from the other side and consider the perspective of students who feel like their free speech might be constrained. So this is anecdotal. I'm thinking to some faculty I know or more conservatively oriented students who I've had in some of my classes. And you know, I've sensed from them that they feel like their speech is chilled, while some students feel that they're harmed by some sorts of speech. Some feel that they're more reticent to speak up in class because of the prevailing climate, especially on university campuses like UIC, which tends to be pretty liberal. So I'm wondering if education is so critical to our democracy and certain groups of students feel like they can't engage in kinds of speech because of their political persuasions, whether there's any appropriate or effective use of the law, not just to protect speech, but actually to promote more open dialogue in any sort of way. I mean, usually we think of free speech as just protecting people, and what happens in the classroom is potentially a good thing if we have open dialogue because the law protects it. What if the way that people are perceiving their speech rights isn't actually driving how they're responding? It's how they perceive their place in the culture more broadly and how they might be censured by other people in the class and so forth. When the university is in fact a place for that kind of open dialogue. So I guess the question is there any place for the law to promote rather than just protect free speech in the context of campuses?
I think there's ways for institutions to do that more than I can see a way for the law to do that. And I'm very concerned about what you say. I'm concerned about the social pressure that students would feel to not express views that are the minority view on that particular topic. And obviously, at Berkeley, the overall culture of the institution is liberal, but we have some very conservative faculty, we have some very conservative students, and I worry about those students feeling chilled from expressing themselves. And then the question is, what do we do about that? And the honest answer is, I don't know, though I've struggled a great deal with this issue. I try very hard at the beginning of every class to explain how much I want my class to be a place where all ideas and views can be expressed. If there's no one who takes a particular side, I will defend that side in the context of discussion. I'm very careful to try, even though I'm not neutral in my own views, in class to let both sides come out. As a dean, I feel responsible for making sure that all of the views come out as much as possible. We had an incident again at Berkeley Law School last year where the Federalist Society had invited a former Congressman, Barr, to come talk about gun rights. And the liberal student groups, it really threatened they were going to disrupt and prevent this from happening. And I sent an email to all the faculty, staff, and students saying, again, that all ideas can be expressed. If you don't like it, have your own demonstration. But you don't have a right to disrupt the speech of somebody else. And if you do, you can be punished for that. And the liberal student groups did not disrupt. They allowed him to speak. They put up notice on billboards of names of people who have died from gun violence. They did a die-in in the hall. But I think that was the appropriate response. I've had instances where conservative student groups have come and wanted to have speakers and didn't have enough funds. And I would go out of my way as the dean to make sure they had funds. Of course, I'm viewpoint neutral. It means I'd have to provide it for any viewpoint. But I especially want to make sure that the views that often don't get heard get expressed. That's not a full answer to your question, but I don't have a good answer for what can we as educators, as professors, as deans, do to try to make sure that our campuses are a place where the students feel comfortable speaking. Because what we're dealing here is with social pressures, not with institutional censorship.
First off, I just want to say how much I appreciated your book and your talk again on its second, third, or fourth read at this point. I'm not quite sure which. And what an honor it is to be on this panel and to share the stage
Likewise with you.
I truly appreciate it, and thank you to Provost Poser for putting this together and to Dean Dickerson for helping to sponsor the talk earlier today. It's just a fabulous program. I have a question that I hope it's okay, comes in maybe 4 parts. Is that okay?
Is it possible to do them one at a time?
We can do, well,
so I don't need to remember part 1 when we're at part 4.
Oh,
so if you could do them one at a time.
Remember them. So what I worry about generally is some of the Supreme Court doctrine around free speech as it applies to a campus. And I worry about these things in the doctrine, but I think they have particular resonance in campus speech and some of the things that we've been talking about. And I'm intensely curious about your reaction to these. So one is Supreme Court doctrine around free speech is built around this idea of marketplace of ideas, right? And the way this works is sort of the more speech, the better. The good speech through this kind of marketplace of ideas will rise to the top. The bad speech or the untruthful speech or the harmful speech will kind of go away through this kind of marketplace. But like any marketplace, the marketplace of ideas relies on things like perfect information, equality of opportunity to speak, equal speaking voices, and I'm not always sure that we have that. We've dealt with this in a different context not too long ago with the Citizens United decision and the backlash to Citizens United, showing that in the political realm, we don't really all have an equal voice, right? Many of us speak with microphones, while other of us speak with whispers. And I worry that in the campus context, some of that may be true as well. We don't come with equal voice, and so I'm not sure the marketplace of ideas is a great analogy. And what I worry about particularly is speech that would exclude students from equal participation in the marketplace. Speech itself that would have that effect. That's part 1.
Okay, can I respond to part 1? And then we do one at a time. Just, I think the marketplace of ideas metaphor is terribly flawed. I mean, it comes from John Milton and John Stuart Mill, but there's all sorts of reasons to doubt that truth will necessarily triumph in the marketplace of ideas. You identify some of them. Some have much more in the way of resources, and they can drown out the other voices in the marketplace of ideas. Also, why believe that people will choose the good and the true over the false and the bad? And we can find places in world history where, at least for a period of time, horrible ideas were chosen and came to the fore. But then my question is, what's the alternative to the marketplace of ideas metaphor? The alternative to allow those who are in power to pick and choose what messages we should hear and not hear, to decide what they believe is true, and to stop the speech that's false. And as much as I distrust the marketplace of ideas, I distrust those in power even more to be making those choices for us. Part B.
Part B. So this draws on Supreme Court doctrine as well. And another thing that I worry about in the context of campus speech, you talked about categories of unprotected or lesser protected speech that are well known to those of us that do First Amendment type law or to law students. I hope they're well known to law students. You can check me on that. But what that relies on, or so much of that doctrine, is the relationship between the speech and the harm. And the Supreme Court has demanded a really tight relationship between the speech and the harm, a kind of imminent relationship, so that the speech imminently causes the harm. And what I worry about in the context of campus speech is that I worry that we may see harm that comes sometimes later, or is not measurable by those traditional standards, or comes through, particularly with social media, may come at a different point or in a different way that we don't measure in conventional incitement law, for example.
I agree, But I also think it's very important to talk about what kinds of harms the law can prevent, what type of harms the law can't prevent. I don't think the law can prevent the harm of people being offended. I don't think we can stop speech on that basis. Because to me, once we go down that path, there is no stopping point. The most vehement argument I ever had with my father when he was alive was whether the Nazis should be able to march in Skokie. My dad wasn't a lawyer, he never went to college, but he just couldn't accept why the people in Skokie should be subjected to the harm. And that's not unlike what you were saying. And I said, here's the problem. If we say protecting those in Skokie is a justification, then why can't it be any time that an audience is deeply offended by a speaker, we can stop the speaker? Southerners who were deeply committed to segregation could have said they were very much offended by those who were arguing for desegregation, civil rights marchers. Now, I can say, I like the pro-civil rights speech, so we'll permit that. I don't like the Nazi speech, so we'll outlaw that. But then you get to exactly what I don't want the government to have the power to do. And I don't find a principle that allows the prohibition of offensive speech that wouldn't get us to exactly that point.
That actually answers my third question. The other thing I worry about in the Supreme Court doctrine is this viewpoint neutrality, right? So the Supreme Court requires government regulation to be viewpoint neutral, even if it's regulating within one of these areas that the government could flatly prohibit speech. And I guess it seems to me that there are some viewpoints that maybe we, and I'm not sure, would widely agree that the government could at least identify. For example, it does seem to me that there's a difference between hate speech and speech that excludes versus speech that includes. And I just wonder whether we can't trust the government a little bit more to make some of those decisions.
I don't trust the government. I don't want this to be political, but I don't want Donald Trump to be able to make the decisions about what speech can go on and what speech can't go on. And I don't want him to be deciding what's true and what's false. And if you have a different president you dislike, you can substitute that, or governor or mayor or president of university or anybody else in that regard. And let me give you an example, again, from Supreme Court doctrine, to why I don't think you can draw the distinction that you articulate. It's a case you know well from just a few years ago, 2017, Mattel versus Tam. It involves a dance rock group out of Portland, Oregon. All of its members are Asian American. It's led by a man named Simon Tam. They decided they wanted to call themselves the Slants. Slants being a derogatory term sometimes directed at Asians. And they said they wanted to do this because they wanted to appropriate back to the Asian community what had previously been a slur. They liken this how the word queer had been thought of as disparaging to gays and lesbians, and then got widely used by the gay and lesbian community and appropriated back. They wanted to register the name of their band as a trademark. But the Lanham Act, the law governing trademarks, doesn't allow registration of a trademark if it's disparaging to any person or persons. And they said, well, this is disparaging to Asians. We're not going to allow it. The Supreme Court unanimously ruled in favor of the group and declared the law unconstitutional. But which side of the line is that on? You'd say, is that hateful because slants is derogatory? Or is this empowering because it's an Asian group that wants to use the phrase? Think of the racial epithet, the N-word. Is it okay if it's used by a rock group that used it, a rap group that used it in its name, but not okay if it's used? I don't know how you can draw those distinctions. And I think that's what the Supreme Court has said. That's why we're not going to give the government that power.
I am right there with you. And so my final question. So the Supreme Court has said that the government itself, when it speaks, is not constrained by these principles. The government can say whatever it wants. And if we are in a marketplace of ideas, don't we have an obligation in higher education, we administrators, we teachers, we students, to say more to combat the speech that we find unpleasant or disparaging? And doesn't the university have an obligation to speak out?
Yes, with a but. Isn't that a great law professor answer? I believe that college and university administrators, chancellors, presidents, provosts, deans, do have the obligation to speak out. And I can point to many instances where when there are hateful incidents, the speech really made a difference. A long time ago, when I was a professor at the University of Southern California, somebody wrote a homophobic slur on a board in a room. Rather than figure out who wrote it and punish the student, the dean put a letter in every student and faculty mailbox, shows you how long ago it was before email, denouncing it and speaking out about why it was wrong. I think that was very unifying for the community at that moment. So I think it's important. And as I said to the Fourth Circuit in the Mary Washington case, I think that it was important for the campus administrators to speak out against what was being directed at these students over Yik Yak. Here's the but. I also think it's hard as a campus administrator to know when are the appropriate times to do that. I know if I speak too much and send too many emails, they're not going to get read and they're going to get dismissed. And it's a hard choice of what are the right situations to do this, and you have to make it in real time at the moment. So when the Ann Coulter thing happened in November, I had to decide within about 5 minutes, was I going to send a message to the students, staff, and faculty about it? I chose to do that. There were other instances where students said, you should speak out against it. And I said, no, this isn't the time. But those are judgment calls, and they're hard judgment calls.
Thank you.
Thank you. Yeah, we have a whole bunch of very good audience questions, so I want to get to them. I want to just say one thing. I don't know if Darby thought of this as we were talking about the merger of the law school, that it would bring us 4-part questions at Campus Conversations. I'm not sure we would have gotten as far as we did. I'm just kidding.
I'm sorry.
Your questions were wonderful. I couldn't help that, since I suffer from the same problem. Okay, so some of these came in themes, and some of them I have heard before, and they raised some of the issues that actually haven't been raised. I also encourage everybody to respond and put your points of view in response to these questions. So I'm going to read 2 that I think are getting to a similar point. The first one is physical safety different from psychological emotional safety? And then relatedly, does the destigmatization of mental illness and an increasing acceptance of mental health as equivalent to physical health lead to an erosion of the difference between physical safety and mental safety? And I think this is actually, just in my own experience, ooh, there we go. Scared myself there. A really important issue, because I think that with the sort of anti-bullying culture that is now pervades the schools, the high schools and the grade schools, that to some extent this idea is being taught. And so they come to college and then we tell them, no, 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 it's not true. So how do we handle that argument? Or what's the answer to that question?
May I add a second part to that question?
Well, you can do it, yes.
And this is sort of following up on Jane's point about safe spaces and addressing both physical and mental harm. Yes, we live in a country that protects and constitutionally affords the right to free speech, but it also affords the right to bear arms. So to what extent are those rights at odds with each other? And again, I want to return to the idea of perhaps we are reading, your thoughts on whether we're reading and interpreting the Constitution in a way that's not compatible with our times.
I do think there's a difference, and there has to be under the Constitution, between speech that causes physical harms, like incitement or true threats, and speech that causes emotional distress. If there's not such a distinction, then I don't know of any principle that wouldn't allow the government to stop any speech that upsets a significant number of people. Because we certainly applaud the civil rights demonstrators, but there's no doubt it caused emotional distress to those who supported segregation. And it can't be, I like this speech, we're going to permit it. I don't like that speech, so I won't. I don't deny the linkage between emotional and physical health, but I think the law rightly does draw a distinction in terms of prohibiting speech because it risks physical harm versus allowing restrictions of speech because of emotional harm. In terms of the Second Amendment, my initial answer is I think that the government can prohibit people from having guns and weapons at rallies. I don't think there should be a Second Amendment right to have guns in public anyway, but even if there is, people aren't going to bring their guns and weapons to the rally to engage in reasoned discourse.
This
Other responses?
This is more of a wondering than anything else, but I mean, I can imagine that we could come up with some pretty solid social science evidence that says certain kinds of speech, like a noose on the door, as you talked about before, could influence some kind of construct like campus climate. And we could see, because of that influence, a strong likelihood that students would suffer a certain kind of harm which would negatively impact their ability to engage with education on a campus. So if we could establish those kinds of empirical links strongly and really document the likelihood of those specific kinds of educational harms, that might provide us with a more solid footing for that sort of argument. Again, we lose the directness that Steve was talking about the link between the act and the actual harm that's taking place, which is really critical for the courts. But it might give at least a pathway for us to think about this. I mean, I'm all for coming up with empirical evidence rather than surmising what's actually happening in the world.
I wonder, though, where's the stopping point of that? Charles Murray published a really awful book arguing that there were racial differences genetically in terms of intelligence. The result of that book is that many people responded to it and showed that the methodology was deeply flawed. And wasn't it better that they exposed that rather than that not happen? Should Charles Murray now be excluded from speaking on campuses because we find his ideas to be repugnant? Well, what about those who oppose affirmative action? Could we say that that's very hurtful to students who believe in race-conscious admission programs? What about those who oppose same-sex marriage? Couldn't that have been very hurtful to our gay and lesbian students? We could go on with examples, and I guess I'm much more comfortable saying, I'd rather have all ideas and views be expressed than to give the campus the ability to say, this idea is not okay, this idea we embrace and you can express it.
If I can just add a little bit to also to your sort of differentiation between sort of physical harm and psychological harm. One of the things that I think also complicates that further is that there is sort of medical evidence and biological evidence that racism and other forms of discrimination have a physiological effect as well as a psychological effect. The lifespan of African Americans is significantly less than whites. And I'm sort of parsing this beyond for the sake of discussion because we don't know how much the speech acts and utterances are part of that overall sort of environment of racism that then affects people's lifespans. How do we, though, account for that within a legal context? Or can we?
I think that we have the obligation to do everything that we can to create an inclusive learning environment for our students of color. And there's so much that we can and must do before we get to the stage of punishing speech. I always am much more comfortable dealing with concrete examples than abstractions. Take Ann Coulter appearing on this or on the Berkeley campus. I have no doubt that her presence causes enormous emotional distress, say, to our DACA students and to our students of color. But is that a reason then to say we're not going to allow Ann Coulter?
Right. Well, and I mean, it goes back to Ben's comment too, which is how do you sort of establish that through hard empirical evidence? And I'm not sure you can, but it seems to me that that doesn't often sort of emerge in the conversation. Anyway,
the Supreme Court actually touched on an issue not too long ago related to this in the Brown versus Entertainment Merchants case, where California tried to regulate access by minors to so-called violent video games. And the Supreme Court struck it despite a wealth of social science evidence that experiencing these violent video games would have lasting and permanent harm on youth who played them. I just wonder, is there any overlap with what we're talking about in that case?
I think very much so, because it then questions whether this is a matter of social science and data or is it a question of value choices. Yeah. I don't think Justice Scalia's majority opinion in that case was about denying that playing violent video games might have some correlation to violent behavior. But he was very concerned, as I am, about where to draw the line. In the 1950s, there was great concern about children reading comic books could create violent behavior. Maybe there was, maybe there wasn't empirical evidence. violent movies. Does that then correspond to violence? And I think what he was saying is it's not a question of what the data proves, it's a question of the value choice with regard to speech.
I think Robert's also, I'm not sure it was that case or some other case where he said that he called it social science gobbledygook or something like that, right? Is that in that case? So I don't think Benny's going to start looking at social science. They're going to start looking at social science anytime soon.
It should be also noted that social science actually doesn't offer conclusive support that playing video games. So I think something that we have to keep in mind is that has to do with the imperfections of the Supreme Court decisions, and that often they're a little bit political as well.
And often there's, as you know better than anybody, often for social science there are debates about what the social science actually shows. In the 1980s, there was an effort to try to ban pornography as the sexually explicit subordination of women. And there was an argument that was made that exposure to pornography increases violent behavior. But then detailed studies were done, and at best they show exposure to violence shows that, not exposure to the sexual material does that. So we could then be having an argument over what does the social science show.
Okay. On a university campus, academic freedom is an important aspect of free speech. In light of the Garcetti decision, should a university affirm this right? What is the relation of free speech to academic freedom?
The Garcetti case that's referred there is a case called Garcetti versus Sabalas from 2006. It says that there's no First Amendment protection for the speech of government employees on the job and the scope of their duties. It involves a deputy district attorney in Los Angeles County, Richard Sabalas. He believed that a deputy sheriff in one of his cases was lying. He wrote a memo to the file to that effect. His supervisor, actually a former student of mine, told him soften the tone of that memo. He refused. He gave a copy of the memo to the defense lawyers he believed he was constitutionally required to do. And then he got transferred to a much less desirable position and removed from his supervisor responsibilities. He sued and said this violates my First Amendment rights. The Supreme Court, 5-4, in an opinion by Justice Kennedy, said there's no First Amendment protection for the speech of government employees on the job and the scope of their duties. I think it is a terrible decision. I argued a case in the Ninth Circuit a week ago Tuesday on behalf of some police officers who were fired for their speech. I have filed a cert petition that's pending right now on behalf of a school superintendent who was fired because of his speech. There is language, though, especially in Justice Souter's opinion, that says academic institutions might be different and Garcetti shouldn't apply there. And there is a Ninth Circuit case on point that says Garcetti versus Sabalas doesn't apply in academic institutions. Now to the larger question. I think it's very important to draw a distinction between speech in a professional realm versus speech in a personal realm when we're talking about academic freedom. When we evaluate a faculty candidate for appointment or a faculty member for tenure and promotion, of course we're looking at the content of the scholarship. There's no other way to do it. If a professor is assigned to teach contracts in a law school, says, I don't want to do it, I'm going to come in and talk every day about baseball, even though the punishment would be for the speech, that speech in a professional realm can be the basis for evaluation of discipline. When a professor grades a student's papers, obviously it's based on the content of those papers. I hope it's never based on the viewpoint expressed, but it's certainly based on content. On the other hand, there is a personal realm. And I think that what a professor says on his or her own can't be the basis for discipline. So if a history department says we're not going to hire a Holocaust denier, I think the history writer is completely appropriate as a matter of professional judgment in saying that. But if a professor on his or her own time wants to go to a rally and deny the Holocaust, I don't think that professor can be fired for it. And I do think that's a very important distinction that's often lost in the discussion of free speech on campus.
Yes. Okay. Recently, anti-gay groups at University of Louisville distributed pamphlets in a classroom where a class on LGBTQ rights was about to begin. What should an instructor do in such an instance? How to balance free speech against managing one's classroom?
Excuse me, bless you.
They're passing on all the hard ones,
Yeah,
Erwin.
looking around and calling on my colleagues. I believe a professor has a great deal of latitude in managing his or her classroom, because that's really the professional realm that I'm talking about. So if I'm having a discussion about presidential power, and a student says, gosh, I really want to talk about the Golden State Warriors, I'm, as a professor, able to say, no, that's not on topic. We're not doing that now. Imagine a student says something very offensive in my class, and I've taught long enough, it's happened. I feel appropriate, necessary for me as a professor to say, I know you didn't mean it to be hurtful, but here's why it's hurtful and not acceptable in the discourse of this classroom. And I think that's appropriate for me to do. I think if in my class students wanted to say very hurtful things with regard to gays and lesbians, that I would have the ability to say, no, this isn't an acceptable way to talk. I think your hypothetical or the real situation is much more difficult because it's handing out leaflets in the classroom. And I don't know if I, as a professor, can say, don't hand out leaflets in my classroom. I think that's really a question of university rules. And it is more speech. It's, you know, if somebody wants to stand outside the door of my classroom and hand out the leaflets to them, that's more speech. We had an instance last year where an Israeli Supreme Court justice was coming to speak at the law school, and the Students for Justice in Palestine threatened to disrupt it. And I, again, said, you can't disrupt the speech. They stood at the door and handed a leaflet to everyone who was going in. It was worded in very strong language, but I thought that was their right to do it. So I'm not exactly sure where this hypothetical fits in that framework.
Yeah, it's a good one because it's actually a class that's about to start talking about the issue of LGBTQ rights. That's what it's how it's written as.
My instinct is to say, yes, it's a leaflet. That's more speech. And maybe I, as a professor, will talk about it. Maybe I'll focus the discussion.
And it doesn't interrupt the flow of the,
Exactly.
the class at some level.
Well, and you may have
Other
a Murray
commentators?
moment here, right? I mean, the speech may actually backfire on the speaker once you vet it and have an opportunity to talk about it. This is a learning moment, it seems to me, for everybody, and an opportunity to perhaps even persuade the speaker or the leafleters that that's not the right view.
And it's different to me if it had been a group coming in and disrupting my class. Take your example. They're going to shout. They have no right to do that. You don't have any. Handing out a leaflet to me is more speech, and I think the response can be very well be described.
Another example that's sort of similar to this, and this has happened on this campus as well as other campuses, I'm sure you've heard these instances, are sort of surveillance where organizations will go into classes to sort of observe what they might see as being politically problematic content of a class, either the syllabus or the professor's approach to the class. Taking that information then out of the class and usually broadcasting it somehow on social media in sort of a hostile or negative light. Does the university or the teacher have any standing in that regard? Or again, is it, I mean, they have the right or do not have the right to enter a classroom in which they're not enrolled to, for the purposes of creating sort of disruptive speech?
I don't obviously know your policies. Campuses can have rules with regard to who can audit the class or who can come in if they're not enrolled in the class. And we have policies like that, and I could go into why, that if you're not enrolled in the class, you can be there only with permission of the instructor. Also, recording can't be done without permission of the professor unless the campus has a policy requiring it. And so to record someone without their permission is actually a crime in California. So you get to that aspect. But if it's a student who sits in my class and takes notes and then passes it on to somebody else, I don't think I've got any protection against their doing that.
Yeah, I have a follow-up to that because I think we often turn or return to the legal framework because we assume that it's going to provide us with some very specific and to a certain extent, relatively clear-cut and direct solutions to the problem. But I think often it limits us as well. And I wonder if, this problem is not just a legal problem, it's also a philosophical problem. And I'm wondering what your thoughts are on this. When we apply the legal framework to the university, we seem to be treating the university just like any other space. But the university is not just like any other space. It's a space that serves a particular function within a society. So to what extent does the law recognize that? And I'll give you an example. I grew up in a country where university space was, in Greece, where university space was deeply politicized. Part of the reason why I decided to build my career here is because I wanted to exist in a university space where chancellors were not elected based on which party they supported and what their politics were. And I'm not going to argue that university spaces in the United States are not political, are not idealized. But to what extent can we make the argument that the university is a space that serves a very different function in a society? And we should do what we can to protect that function.
A couple of thoughts there. One is, I agree with you that the university performs a certain function in society, but the question is, what conclusion do you draw from that? I think that my conclusion is that the university should be a place where all ideas and views should be expressed. That if there's any place that really models the marketplace of ideas, it should be a college campus. I worry that the alternative would then say that the campus can say that any speech that it believes is inconsistent with its mission, it should be able to stop. And so in the early 1950s, campuses said, communist speech is inconsistent with our mission. The president of Yale said, we're never going to fire a professor being a communist because we're never going to have communists on our faculty. Well, we now decry that, but just change the topic if we give the university the power to do that. The other thought, in terms of where you started, of looking at law, one of the points that I constantly want to make for my students, especially when I teach First Amendment law, but more generally, is there's a real difference between the right to say something and whether something should be said. And people often ignore that distinction, and it's an enormously important one. Just because you have the right to say it doesn't mean you should say it. And there have been some instances in universities where professors have said truly outrageous things. Amy Wax, a professor at the University of Pennsylvania Law School, saying really hateful things. And the dean denounced what she said. And she said, but I have the First Amendment right to say it. Of course she does. But he also has the First Amendment right to say that that was really hurtful and inappropriate. And yeah, you have the right to say it, but that doesn't mean it should be said. And we all learn from a young age that there's certain things that you don't say in public. You don't say to others because they're so hurtful. And I think it's okay to teach our students, yeah, you have the right to say it, but that doesn't mean it should be said.
Thank you. I was hoping to hear something like that. Everyone has the right to an opinion, but have they earned that right?
I think your instinct on this is right, and I appreciate the balance that you bring to it. The university is a special place, and we need to preserve the free speech rights of everybody around to fulfill the special mission of the university. But the institution takes a very important role in calling out harms, but it's the institution's discretion and the people within it that really have to do that kind of work. It's a difficult balancing act. I don't think there's a clear answer in a lot of these situations, but I think appointing university leaders at all sorts of different levels and making sure the institutional climate is in place to really call out those kinds of harms while preserving speech is probably the key to making these kinds of educational conversations really work.
Well, and I think to take it even one step further along the lines of thinking about, the question of when administrators should send out emails because you don't want it to just be a weekly thing and then people stop paying attention. One could imagine a situation where the university decides to do something that may really be walking the line on free speech, in other words, denouncing something or not having someone come and speak, and be willing to be sued for it for the benefit of the culture. or for the benefit of a certain group of students that they feel will really be harmed in that instance. I'm not suggesting that's a good thing to do, but it is something that a university could do in the sort of sue me realm.
Can I do an accept there?
Yes,
the
please.
Trump administration has now put out proposed rules from the Department of Education. Comments are due next Tuesday. These rules are about free speech, and one of the rules says that if there is a judgment against a campus for violating free speech, it's a final judgment of a court, that is then a basis for depriving the university of its federal funds. And that to me is very frightening, because it's now up the ante against the university that wants to say, okay, we're going to take the risk of litigation because we want to stand up for this principle, the law's uncertain. There's no reasonableness defense built in for the university. And I'm very afraid of this regulation, because it would really take, if I were a university counsel, I'd be a lot more hesitant about taking chances in litigation.
Fair enough, absolutely. Okay, I think we are at the end, so let's thank our panel and Dean Chemerinsky again.
Such a pleasure.
Thank you. Excellent. Thank you so much.
Thank you.
That was fun. It was so great, but